Right. I'm basic as hell. That's why I'm in the house. Okay, so of course, this is the Uniform Commercial Code. We're coming out of, the volumes, the questions that was based on and around this particular topic and purpose. Last time we met, we were in Article 1. So how do you feel? Did you get a chance to rewatch that video?
I watched like the first part of it. I didn't finish it, but
So how do
um,
you how do you feel? So just in general, coming into, today in the information.
um, I feel, how do I feel? I feel like I still have to. I've noticed that like when it comes to like this particular part of the information, I definitely have to read it more than once.
Right.
Or
We all do.
yeah, because I've noticed and I'm like, oh, I've read like it, and I noticed that every time I come back to it, I see something different. Like, and that's important
Right.
for me. I'm like, even like after the last time that we met, I went and I started looking at like, the different parts of it. I'm like, but it's like when you read it and like, sometimes it's frustrating. I'm like, okay, why am I not getting it? Like, I'm
Mhm.
not someone who has a hard time. Like,
Just overstand that, and this is the part of your overstanding. Overstand that you are learning.
right,
As we learn, we do things to make us familiar. As
right,
we become more familiar, then we begin to know about it. Once we know about it, we begin to research things that make us knowledgeable about it. And then once we're knowledgeable about it, then pretty much from all we collected and gathered, we'll be wise enough to execute. So everybody, me included, have to read stuff 4 or 5 times. It's gonna go from reading it 10 to 6 to 5 to 2 to knowing what your purpose is, and then going to something and instantly relating it.
mm,
Instantly looking at what happened and determining why, how, and all of that based on what's happening.
right,
So don't let that be something that allows you to be hard on yourself or create a block because you go in not really intimidated but skeptical of yourself.
mm,
Always go in with intent. You know the reason you're here. Stick
right,
to that so that it's always in the back of your mind as you intake new things because the human can only think about one thing at one time.
right,
So we have to see what we seeing in the present and then stop looking at the present, go back to think, and then come back to the present and relate the two.
right.
So what is the first thing you should do when you get to an article?
The first thing that you should do when you get there,
Like right here, what is the first thing we should do?
read the title.
Okay, that's cool. Yeah, read the title. First thing we should do. We want to always look at things that are bold and conspicuous, and that is the only thing that is bold at the time. So, yeah, we want to read the title. After you read the title, then what you want to do? We know
Um,
that we're talking about general provisions when it comes to transacting in Article 1 of the Uniform Commercial Code. What's the second thing you want to identify before you jump into actually reading it?
the sections.
Right. You want to look at the different parts so that you know what it is that you're going to be getting yourself into or learning about. So, part one is general provisions, and that's what we covered last time. We
Right,
spoke about, the general construction of it and what was its purpose. And, this purpose of it being created is to help our underlying commitment to sellers,
right,
merchants, buyers, whoever we have entered into this relationship with. The Uniform Commercial Code comes in and help promote that business and help us meet our obligations. It creates and helps us create money, and that's what we're going to get into today.
okay,
So another part is part two, where they speak about the general definitions and principle of interpretation, and that is what we're actually going to get into today.
okay.
And then they have part three, where they speak about the where does it apply, what does it apply to, and what territory and when. The general rules when speaking about transacting in the Uniform Commercial Code taking in effect. You always do. We have identified all the parts. So we know that we're talking about some general principles, rules, things that we should interpret. So things that we should be knowledgeable of, things that we should notice. So just looking at 1-202, 1-201, and 1-203, what is the first thing we should notice and be knowledgeable of?
Definitions.
Yes. So each and every time we go to an article, we want to always look at the definitions. We want to look at the definitions to determine what is it that we're about to talk about? What is it that they're saying that we should be noticing and knowledgeable of? What is they saying that we should distinguish from a lease? Must be a sale. They want us to distinguish the difference from the security interest that was given in that sale, how that lease is valued. We need to understand what this lease is about and how we get reasonable time during seasonable moments, like months, years, to
Right.
presume the value in these documents and lease them to another. So here they're giving us general provisions under transacting, giving us the purpose of giving this value to one another.
Right. That makes sense.
Okay, so had you come here alone and you just looked at this section, what would have been going through your mind?
Um, if I would have just come here, I would have just looked at what the titles were first. And well, obviously I would read the definitions first, but I would look at the titles, but I don't know per se if I would have interpreted the way that you just did. Like you're saying, like, okay, what are we talking about here? We're talking about general principles of how we're supposed to interpret this information. I would not even to have thought to even do that. I would have just jumped right into it. Like, okay, general definitions, let me read that. But now that you put it the way you put it, now that makes me make sure that moving forward, when I am reading or I am discovering, to actually make sure I'm reading it the right way so that the information I am reading in that section makes sense to the topic or the subject.
Right. You're connecting those dots. They're letting us know that our purpose for transacting is leasing something. And that lease is going to be distinguished from the security interest that we give in the very, very beginning. I come in knowing that my ultimate and purpose goal is to use my goods that come in the mail. I know that I'm not making a sale with them because someone else has done that. I know that I'm conducting a lease.
Right.
I'm leasing those goods. So it's distinguished from it. So that's the first thing. We're in Article 1 that they want to talk to us about. They want us to notice and make knowledge of, because this is the reason and the purpose why you receive your bill, why you receive that good. They're going to talk about that more and get more in depth in Article 2, where they speak about the sale, which is what comes after and during the transaction
Right.
between the seller and the buyer and a third party, as we learned in Volume 1 and Volume 2.
Right.
So yeah, good job. Just connect those dots. Whenever you see 1, 2, 3, they are 2 points really that they made.
Mm-hmm.
Because you got 1 through 3 and then 4 through 6, 2 parts. They in the threes. And literally it's under part 2.
Wow. So are they
And
always
then literally the topic is about general definitions. And so it's not or, but 2 things.
that?
Principles and the interpretation, how you should take it, how you should receive it, perceive it, how you should the presumptions that you should make whenever you receive that good in the mail. They're talking about you being knowledgeable of that purpose. And I know that that's my purpose. That's what I want to use in order to meet my undertaking, my underlying purpose, to meet my commitment.
Yep.
I agreed to pay. I can't sell because I read in my agreement that they said that they gonna have a right to sell. And then they also speak about the lease of goods. And that's something that we covered in Volume 1, because the purpose of here we are with the purpose.
That makes sense.
And this differs and distinguished from the security interest because we give security interest to them and we just get a piece of that interest. Payable,
Right.
small payable,
Right.
for allowing them to benefit.
Right.
So let's jump into the definitions here. So what is the first thing you want to do?
Um, we'll read the title in the first paragraph.
Okay, so we definitely want to look at the title because that is something that is bold and conspicuous. We also want to examine the document. So you have examination and inspection. You want to examine a document to see certain things, to notice. Remember in 1-202?
Yes.
to notice certain things. So we're going to examine the document. So we see the title. It's bold and conspicuous. That's what they want us to see. And we'll find that out soon too. We see other bold, words. Okay. We see a couple of hyperlinks. We notice the different numbers, 21, 22, 23, 24, the order. And like you said, we notice paragraph A and B. 2 points, 2 parts that they are making. And they're about to first start off by telling us just in general. These are the general terms right here. So you see definitions, general terms. What happens when you transact? When you leave your principal place of home, your business, your home, when you leave that place and you go out into society and you make an agreement with another, that transaction, we're about to talk about what happens from it. What happens? What's the purpose? How can they help you serve your purpose, which is to pay? That's your promise, your undertaking. So you can go ahead and take one for me. Stop where you think you should stop. What is something that you should notice in paragraph A?
Something I should notice.
Yeah, because now what do you want to examine it for? Because just to break it down, what we did before was examination. Us reading it and breaking it down is going to be the inspection. It's going to be us really, really looking into it. But before we really, really look into it, what can you examine and notice about paragraph A?
That it has
What's something? Okay. So it's giving us our subject.
Mhm. The or.
So they're talking about a lot of different parts. How many? Two of them. So it's about, well, here go another one. So part A gonna be kind of heavy, talking about the general definitions. They're gonna be letting us know, in general, this the terms after or whenever you initiate something in commerce.
Okay.
So go ahead and read paragraph A and stop where you think that you should stop and elaborate.
Okay. Unless the context otherwise requires words or phrases defined in this section or in the additional definitions contained in other articles of the Uniform Commercial Code that apply to particular articles or parts thereof have the meaning stated. So basically, unless the text otherwise requires words defined in this section. So are they saying that okay, so what I gather from that is that they're saying that when you see these words in this section, this is what they mean, unless they provide an additional definition.
Right, in another section. Good job.
Yeah.
Absolutely. So that's the first point that they made. So you're going to see these definitions, and in this section, this is what they mean. But unless the context in another section requires, that's the reference.
Right.
So that's the first point. Good job.
And then B, subject to definitions contained.
What about the second point they made here?
Oh. Or
an additional.
Oh, I thought you were talking about go to B. I'm sorry. Or in the additional definitions contained in other articles of the Uniform Commercial Code that apply to particular articles or parts thereof have this meaning stated. Or the additional definition contained. So are they saying that if you see these definitions in other parts and it doesn't have, wait, I think I'm confused. And the additional definition contained other articles that apply to particular articles have the meaning stated. Oh,
what words should stick out to you in the area that I highlighted? What do you think?
Um, additional definitions.
Right, additional. So another one plus this one.
Oh,
You're going to be getting into other articles that's going to cause for you to add action with whatever definition is described in that particular article. So let's
so
say Article 3 describe check. You are able to combine check and action together. They're going to tell you in Article 2 at the very bottom, any definition that you do not see described here, refer back to Article 1. Because it's that definition plus the definitions that are described in Article 1. So you're always going to be connecting the dots back to when you transact.
hmm,
Whatever you don't see at that present moment defined goes back to the principles of when you made the agreement.
okay,
That's why everything is pursuant to the agreement. Anytime you don't know something, anytime you're stuck, you're going to always go back and be looking at the agreement,
right, okay,
looking at those terms. Those terms are going to match commercial code standards reasonably. So we're about to learn about those general definitions that we're going to see described in those contacts and actions that we can take against documents in the Uniform Commercial Code. Why? What's the purpose?
to use them.
So not only are you going to get the definitions in this section, but there's going to be other ones that apply and contain. And whenever you don't see it, then you just go back here and you can just rely here. Or you can have an addition of both.
So are you saying that sometimes like you're going to be utilizing a definition in another article plus this definition here?
Right, because you're going to be transacting at that time. At that present moment, you're transacting. So the verbiage and the language that you say is going to include definitions here in transacting, plus whatever other language that is inferred. Maybe you said check. So whatever definitions is listed out under Article 3 is also going to apply with this in addition, because we're transacting at that time.
Got it. Wow. Wow. Okay. And it's
And
applying because that's what we're doing at the present time,
exactly.
right?
And exactly. And you're going to see down here how agreements are made. They're made found in the language and the circumstance.
Right. Yeah.
That's how we make agreements. And that's the first thing they're about to describe in Article 1. General. In general, our language creates agreements. And it must be according to commercial standards. It must be reasonable terms, reasonable definitions. So that means everyone, all parties, must observe the Uniform Commercial Code. You're going to see verbiage all up and through here that's going to be on a lot of your agreements. This is what it means when you decide that that bill, that document is your value and not the car. Because here they're going to be talking about that personal property, what you have interest in, because
Right.
you gave up that security interest.
Right.
You can read B now, unless you have any thoughts, anything to elaborate on.
Um, no, not at the moment.
Okay.
Um, okay. Subject to definitions contained in other articles of the Uniform Commercial Code that apply to particular articles or parts thereof.
So what did they say? That these definitions that you about to read is what?
Is subject to the Uniform Commercial Code.
And other articles.
Mhm.
So the
So they
definition that you about to read is gonna contain to Article 2.
right.
These definitions are subject to Article 2. We sell our agreements. for these contracts.
Mm. So why do you say it's applicable to Article 2 and they didn't say that specifically?
Because
It
it comes directly after.
got it. Okay.
And when we conduct that sale, that's when we give the security interest. The sale is for security interest. Our transactions is the opposite of that. It is distinguished from a sale. So it is a lease.
Right. Right. Right.
See,
Right.
they
Right.
told us that in the very beginning.
Right. Yeah. The lease. Just
Distinguished from security interest.
got it.
Security interest arises from the sale. And that's Article 2.
Got it.
Okay. That's something that, of course, the next time we met, that's what you will have noticed because we on step 1. So if we on step 1 and we go to step 2, we're always going to look back at step 1, and step 1 would have told us that about step 2.
Right. Okay.
You can go ahead and take number 1.
Okay. Action in the sense of a judicial proceeding, includes recoupment, counterclaim, set off, suit in equity, and any other proceeding in which rights are determined.
So how many things are considered to be action?
1, 2, 3, 4, 5. 5 or more.
Exactly.
Okay, you said it.
So, right. So one may be able to take a judicial proceeding, but normally that's going to happen in counterclaims, set-offs, or recoupment. Now, any type of suit that's in equity. You want to sue for a claim of equity. We don't make claims to equity because we made an agreement to give it to them when we gave them the security interest. So we shouldn't be trying to do that. We should be trying to take the action after the end, which is the proceeding where our rights are determined.
Mm,
Because we gave them the right to equity. That's what we want to be talking about, not the first part, because competently we should have done that.
right.
That's the point of us making the agreement.
Mhm.
So yeah, it's based on equity.
Right.
But we want to take other proceedings, which speaks about the rights that are determined so that we can get remedy.
The rights that we have to the value of the document, right?
Document. Exactly. Because that's what we found our purpose to be in value 1 and value 2.
Right.
So you see how you can operate.
Yes.
It's not even an or, it's an and. So
Right.
both is happening and will happen. You're gonna have people taking people to court, and then you're gonna have people like me who's not. I'd rather
Right.
have a proceeding where we just arbitrate and figure out the rights here.
Right.
Let's do this without a judge. That's what everybody make you agree to because they don't want to go and get all into this.
Right.
You want to determine your rights so that it leads to a set off, not a suit for equity when we gave it to them. We shared it with them. They share it with us too, each and every time we receive that contract. Just not the whole thing.
Right.
So how do you feel about, action and just understanding your options that you have to take action or the different options that, can take place?
So when I read this first, right, before your interpretation, I thought
Mhm.
the first part, well, my thought process was the first part of it referred to like the other side, like them, and then the other after the end was us because my process was like, okay, well, they do set off, they do
Right. And that's where your brain should be. So we perform the other proceedings. We don't perform set off. They do. So
right,
we
okay,
operate in here. We just do what we have to do here and give them equity by
right,
making this agreement. We don't take it any further than that unless you want to take them to court, which they ask you not to bring damages against them. They ask you not to take that type of action. They want this type of action where you're proceeding the bankruptcy,
right,
when you're proceeding your rights to credit, when you're proceeding your rights to that instrument. That's what they want. That's the type of action they want. Not this one. Unless you're mad about something. or
Right.
unless you found to be wrong. They're going to be found when we determine the rights to be wrong, so they'll set off
Right.
due
Right.
to
Right.
the equity that is involved, not necessarily because of it, because they have it still.
Right.
We're just speaking about our portion that we're perceiving and determine our rights to it once we actually receive it.
Right. Yeah, I want to be on this side.
Okay.
On the end. Okay.
So that's the point of looking at or two.
Mhm.
When we do get in one, because that or is going to let us know that we could do one or the other. And then that and is going to let us know like we got to do or participate in both. And we
Right.
have to take an action of equity.
Right.
That's what happens in the very, very beginning when we make that agreement.
So in this case, like right, so for action, we are doing both, but our duty is on this side for that to happen.
Exactly. So after we give that equity and we take that action, what we do after shouldn't still be on this side because we already did it. We need to be doing
Right.
this.
Right. Just
We not
determine.
mad at them for this, knowing they got paid in full, and we mad because we just taking a little payable. Man, just proceed it. You're gonna get that full amount over 72 months.
Right.
Stop being
Right.
so greedy. Unless you want to pay it off in the first 3 days.
Right.
Take that type of action where you proceed in your rights to that document after the equity has been given, after the agreement has been activated,
Right.
after we've bargained the facts,
Right.
after we communicated, talked about it.
Yeah.
So we taking action. And it could be both. So here you go, where people are not wrong for suing. You can take that type of action if you want to. But it's gonna lead to what rights or which rights is determined in the proceeding. And 9 times out of 10, you're not gonna always be right. Because the first part
Right.
is gonna be determined what type of fault you found. What you talking about, what you leaning on. Because other than that, you agreed to something.
Mm-hmm.
So what about two?
Two, aggrieved party means a party entitled to pursue a remedy.
So what type of clarity or what do you get from that?
Um, well, I first have to know what is meant by party and remedy, but party entitled to pursue a remedy. Oh, so anyone who's, I guess, entitled to receive something from it
Because they did what?
because there is
Or because of what?
interest,
Action.
action. Oh, okay, action taken. Yes, because you can't have remedy without action taken. It has to
Right.
come
So
first.
you don't have to know what party and remedy is yet. You just know that the action of an aggrieved party is due to something, some sort of action that was taken. Party and remedy is something that's going to be defined later, so you know it's coming.
Right.
You know that any person who take action, whether they give equity or pursue any rights, can be an aggrieved party, and they are someone who is entitled to pursue rights and remedy, either
Right.
determining the right or remedy. The
Because you have to
party,
have before you get remedy.
right? Have to take some sort of action. Have to give something. Something has to happen. You have to transact with someone first. Whoever transacts with someone is an aggrieved party. Someone who is entitled to a remedy, entitled to determine the rights, whether it is an equity set off and counterclaim, etc.
Right. So this is actually in order.
Yeah, most definitely.
Okay, I just recognized that because I was like, wait a minute, it's the action first, and then it has the aggrieved party, which reference the remedy, and then it references the agreement about bargaining. So I just
Exactly. Huh? It's definitely in order. So that's why it's ultra important to read the definitions no matter what you're reading.
right,
Because they're telling you what's going on. They're telling you the story. And they're
right,
telling you that any person who is a party to an agreement has the right to pursue remedy
right.
for as long as you take an action above. So how you feeling? What's your thoughts? Where you
Like
at?
I just noticed like that it's literally in order. So that like I never realized like that's what the numbers are referencing, I guess. Like it's like
Yeah.
okay. this, second, third, this, like it is giving you like, I guess like a flow, if you
Yes,
will. And I never noticed that. I just thought, they're just listing things, but I didn't realize it was like there was an order to it.
it's an order, just like our exam was.
Right. It definitely was. When I had that one question, it was like before it said minimum payment. I was like, yo, she really, really like that. I didn't notice it while I was going through it.
It's an order. And just like we learned in school, you can count forward and you can count backward. So that's what you should do to understand and overstand things.
Right.
So let's get into agreement.
Okay. Agreement as distinguished from contract. So first thing, they're telling you that they're different. Uh,
Yes.
so I noticed that means the bargain of the parties in fact as found in their language or inferred from other circumstances, including course of performance, course of dealing, or uses of trade as provided in section 1-303. So they're telling you that the agreement is where you bargain the facts. And it's also different from a contract. That's the first thing they say.
Yes.
Um,
And then they tell you how to bargain those facts.
yes, by the language, right?
Mm-hmm. Or
Whether
how,
right. So when they say as found in language, meaning like they're like the agreement.
yes, the agreements, the terms, the definitions, what we say, how we speak, what we talk, how we communicate.
Right. So what do they mean by when they say like or infer from other circumstances? What would those other circumstances be?
From circumstances. So your contract and your agreement is a distinguished.
Mhm.
We create our agreement based on these facts. The facts of our agreement is based on the language that is inferred. There's or that is, we use.
Right.
Other circumstances is going to be where you're dealing with that contract. The
Mm,
agreement that you make for that contract is found in the language. You're going to find that or other things that are inferred to give these facts or give you something to bargain any fact with, to prove something with, is going to be found in that contract, in which is included in the course of performance, course of dealing, and using the trade. That is what we're using to bargain and make facts with. We're creating these contracts.
right.
We're using these contracts, and they are found in our language and the circumstance. So at the point of us creating this agreement, it's for security interest. At the point of us using this contract, is to lease it.
Right.
So that's the circumstance. So it is inferred in the language depends upon the circumstance.
Right.
What's happening? It's inferred by that present moment, and it includes how we perform when we receive it or in that circumstance, how we deal with whatever it is, the subject, what we have in our possession, and how we trade them.
Yes. Okay.
Buy, sell, trade,
Right.
lease.
Yes. And that contract is that's what's considered when we get the later
Right,
document. So
right.
that's
Your bill
to sell.
to lease.
Right. Well,
We
yeah. Yeah, yeah. But
we
is it like
lease
a
contract.
contract for sale at that point? Right? Like
Right.
different
Exactly.
for a
And our
contract.
agreements is a contract to sell. A contract to sell us these contracts later. They're going to make sure that they deliver it to us, conducting and sell later. Once we receive it, now we have a contract for sale. How do we turn that contract for sale into use or put it into use? By leasing it, creating a lease contract.
Right.
That is inferred by our language,
Right.
and they'll agree to it. That's how we perform and deal with trading our documents.
Right. Got it.
So we must communicate. We must know the information so that we can talk about it, Get someone to agree to it. Prove to them that it exists versus not existing.
Right.
So agreements is distinguished from contracts when it comes to an aggrieved party who is pursuing remedy. So you're not pursuing remedy for that agreement that you created with CarMax. You're pursuing remedy for the contract. So the
Right.
action that we're going to be taking is going to be other proceeding, not
Right.
one like this when that already happened.
Right. That makes sense.
All of that is going to be inferred by the circumstance, whether we're performing at that moment, dealing at that moment, or trading at that moment. Our language is going to tell them that. What we communicate to them is going to tell them that. Who that? You could take number 4.
Okay. Bank means a person engaged in the business of banking, and so both includes a savings bank, savings and loan association, credit union, and trust company. So there are no ors here, so everything is included. I noticed
Mm-hmm.
that. Yeah.
Is included with dealing with what or trading what?
Contract. No.
And
Well, it depends who we're talking about, right?
we in transactions. We talk about the very first thing. We haven't even got
Okay.
to a contract yet.
It's the agreement.
The agreement.
Yes.
Who have those?
The bank.
And all of these other people
Mhm.
have the agreement. Waiting on the aggrieved party to pursue a remedy. Take an
Yes.
action.
Take the action.
And
That's
not one that's going to cause damage. Because all our
other-
agreements say do not cause damage.
right. So it's those
Now,
other proceedings.
and
Wow.
people saying, they saying I did fraud. Why? Well, you're at fault. Because the agreement asks you not to bring no damages against me. What I infer or think that damage is considering the circumstances, we talking about a contract and you on something different.
Right.
You at fault for doing what you said you were going to do according to the agreement. You're misleading. You're incorrect. So I'm going to
Right.
close your account. Simple.
Right. Yeah.
When you create an agreement, you have conduct, obedience, and diligence. That's what volume 3 talks about. Telling you that there is a manner in which you are to proceed in dealing with these documents, a practice and a method. Well, we learned in volume 1 and volume 2. We must be knowledgeable of that. That's the first thing they're telling us in Article 1 to notice. The agreement. Notice the agreement.
Right.
And see what you contracted to do with the bank. Not with that same person you're trying to impose liability on. That's why they're closing your account. If
Mm.
Capital One is not a bank under the jurisdiction in which it served you, then you're misleading. You're false.
Mm.
So no, they don't accept that coupon. A lot of these companies, capacity. So what's your thought? What
So
you
my
think?
thought, what I was thinking is, so if we, so when we're, so basically, are they saying that when when we're wanting to use the contract, aka the document, we're dealing with the bank?
Exactly. We're not dealing with the seller. They just
Mhm.
transferring it to you. They just negotiating that document to you that they received from the bank due to the agreement that they gave to them, giving you the receipt.
Mhm.
Something for you to make a claim to and take action. How are you aggrieved when it comes to that document? That's the question.
Mm.
So that you can pursue a remedy. If you don't have no reason to use your bill when it comes in the mail, you're gonna pay a USD for it. If I examine my document and inspect it and I find a reason, then I got a right to pursue that document. I know I got interest in it. It's mine. I got ownership in that document. How could you possibly try to sell me something that's mine?
Right. 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 Right.
I had made an example to one of my mentees. You let me borrow your car, and I bring you over the weekend, and I bring your car back on Sunday, and I try to sell it to you, sell it back to you. What type of sense?
That's funny. I gave you
Like,
something you perceive as value, but I want to sell it back to your ass.
right? No, we got common ownership, if anything. But I mean, look, I'm leasing it to you. You only gave me your car for a weekend, so I'm gonna claim I own anything when you leased it to me.
Right.
You transfer your rights and possession to your car to me
Right.
for a weekend, so that
Mm.
you can gain money, USD. Unless you gave it to me for free for the weekend.
Right.
So how you feel? You ready to move on to bear? They talk about that in Article 1.
I can't
So,
see it.
oh, you can't see my screen. Okay, I don't know why. Did somebody call me or something?
I see your logo, but I don't see what you were sharing. It's not sharing anymore.
Okay, well, it's still recording.
Yes. So I guess the other thing I'm thinking is, so they're telling us that if we're using the document, we're dealing with the bank. So that means that if that's the case, the agreement should tell us who the bank is.
Exactly.
Okay.
It's going to be found in what?
In their language. In their language. Mm.
And that's how you bargain. What?
The facts.
Period. They don't care about your opinion. They don't care about what you think. They don't care about none of that. What's the facts? Where's the language that inferred this type of circumstance that you're talking about? Where is that? That's what I want to see. That's what I'm interested in. Because that's what's included in the course of performance, course of dealings, and the use of the trade. Anything else is what you think, how you feel, and that's not the type of business we in.
Right. Mm.
That's the first thing that they said. We are in Article 1.
That's crazy.
Outside of what they said before we even got here, where they were telling you the purpose and all of that good stuff, they said all of this in Article 1, the very first step.
Right. That's crazy.
And people skip to Article 3. How could you do that?
Right.
How can you run before you walk? How can you crawl before you walk?
Right.
People don't want to start here because they impatient. They want to pay their bills. You got to crawl. First, you got to be born. So this ain't even really crawling yet.
Yeah, be
This just
born.
being awakened. This is just being alive and woke to the
I be
information.
of the world.
Right. Then you gonna start crawling. So that's probably gonna hit in Article 3 when you realize it's not what you should have jumped to and it's not what you think it is. Then you're gonna begin to crawl.
Yes. And you know what's crazy? This is so wild because I've literally went through, I promise you, I went through all these definitions, read them and everything, but did not see the connection. That's what I missed. I missed that there was a connection between the flow and who they're talking to and how they're showing you in order how you're supposed to perform, act, whatever, read. And I just like I come here, right? I'm all right, cool. Action is this. Agreed party is this. Like that's how I'm
Mhm.
not reading it, like it's connecting. And so
Yeah.
that's what I'm missing. Like that's the piece that I've noticed that I'm missing. Like I'm not
Being present
yet.
and dealing with the stock, which is the asset, the paper, the document, and the flow, the
Right.
rules, the regulations, the principles that's surrounding it. And that's what mentorship is for. Like this right here is what mentorship is for.
I would have never. Okay. Let's just be honest. I just would have read it like just like, hey, it's almost it's like, all right, I'm gonna give you 20 definitions. Just go ahead and read these 20 definitions. Like that's how I was reading them. But now that I see the way that you're going through it, now it's like I'm connecting the dots now.
And you will be able to read anything that is in front of you during that circumstance.
Yes. That's crazy.
This
Gratitude.
is, man, gratitude. This is handling business. Like information that they made public record. We're not looking in no secret file of mine.
Right.
Like, we not. They didn't hide it. They just need our help, but they didn't, I guess, help us help them, but they kind of did. But then I don't know. I don't know. I don't know.
Well,
It's
have
kind of
you
like it's kind of like what we was talking about before we started recording. It's like one of them things where you know what I'm saying? I can't say really one way or the other. Because
right.
I know the benefit in both.
Right.
Crazy.
Yes. So like
And that's where you get.
bank
No, go
be
ahead.
would that bank be referenced like as an intermediary? Because I've seen that language.
It just depends on who transfer you the document in their capacity. Was they dealing with an intermediary? Do they serve as the intermediary? So that's when you look at the who's liable. And
Okay.
that's when you go and decide, okay, who am I actually doing business with?
Okay.
People gonna discover that Capital One ain't a bank. Like not the Capital One who transferred them they bill.
Like,
Now, is there a savings or trust company or association or credit that's involved with them? Possibly, but not with the person that transferred you your bill. Not under whatever jurisdiction or applicable law. Because you
mm,
want to trade in another jurisdiction or under applicable law. You want to share with somebody else. You want somebody else to deal with the document, perform to it under their circumstance.
right.
This is why you have different laws, different places.
Right. Because it'll be according to the circumstance.
Yep. What jurisdiction are you under?
What are you claiming?
Right. What's going on?
What do you see as value?
Like, what's happening?
All those things that come to my mom when you say that. Like it really just really depends on your circumstance.
Yes. So that's why I can't answer people questions. People are like, look, that's why I stopped the retreats. Because I don't know everybody agreement, but I can tell you and give you a method. Your process is going to determine by your agreement. If you don't understand your agreement, then you're not going to understand the process I'm giving you. So I
Right.
stopped.
Right.
Because people don't understand what they want to do. They don't know what they want to do. They just know that they want to be bill free, but they don't know the difference in the agreement and the contract. So if you don't know that, then you don't know where to start.
Right.
With
Agreed.
understanding what you truly want to do. And it's just like, yeah, out of 6, 8 hour days, I can't break that down too.
Right.
So I stopped them.
Yeah.
It's way more than what people think. It's simple. It's really simple. That's what we discovered in value one and value two.
It is simple when you got somebody like you. I feel like because I'm telling you, I've been reading all up and down that art that UCC stuff. But it's like when I can do it with you, it brings more clarity. Like it brings more perspective. It opens up. Like again, like being present. But I feel like you also have to have the right eyes and ears to even be present. And
Yeah.
sometimes I feel like I don't pick that up. Like I don't know.
Everybody struggle with that.
Yeah.
And then this is where you have people saying, oh, I was talking over your head. Like, no, the point of your mentorship is not to allow me to talk over your head.
Right.
Because how I talk, what I relate things to, the clarity that I provide is all in my language. Because of
Yes.
what I've discovered, the terms.
Right. Thanks.
So it's like, whoa, whoa, wait, hold on. I wasn't there yet. So it's like, oh, okay, okay. Under that circumstances that we end, I need to bring it down a notch. I need to go back to the course of performance. I might be talking about some dealing that they don't know nothing about yet because they still stuck on the performance. How did we perform to this? How did this happen? Like everybody's still there. What happens when you deal with the contract now?
Right.
So that's why I be saying in my stories, like move up a level. Like I don't know if people think I'm trying to be funny or not. I don't know how people infer my language, but I'm saying what I'm saying because it's what it is. It's not because I'm saying they're trying to, like I don't know what nobody doing. I don't care about none of that.
Right.
This is in black and white,
Right.
and I overstand it. I understand it.
Right.
So that's it. So that's why I also overstand and understand how people doing any and everything because look at this. Look at how they left the agreement up to your language.
Right.
What's inferred by your circumstance? They're like wide open, free, freedom.
Right.
Like for real. We all bear that freedom. It's not just for one person. We bear that. Everybody who decides to enter into an agreement.
Right.
So what's bear? Because you see people saying pay to the bear. Let's see what they're saying.
Yeah. It means the person in possession of a negotiable instrument.
Isn't
Doc
that obvious?
yes.
If you got the instrument, wasn't it paid to you?
Yes.
Why are you saying that again? Document and title is going to refer to your contract. Negotiable instrument is going to be the agreement, and you're going to see negotiable instrument on your bill because it's due to that agreement. You're dealing with a document of title that has a certificate of security attached, or maybe it don't. Maybe it's just a document of title, something
Right.
that is payable to a bearer, us, the one who has it, any other person who bears it naturally, and it's blank endorsed because no one has made a claim or took an action to it yet.
Right.
No signature. So everybody gonna get to bear a negotiable instrument. Everybody, no matter what level. If you're on a level of agreement or contract, you're gonna bear a negotiable instrument, a document, a title, some sort of certificate of security that is gonna be payable to the exact same person who used to bear it or bared it.
Right.
Who that person is, we don't know because it's blank endorsed, and that's what we learned in volume 2. We don't know who's representing another, but we're gonna bear the document, and we'll begin to, change this blank endorsement.
We'll negotiate it.
Okay.
That makes sense.
Okay.
All right.
Um, what we bearing?
The document.
What is it called?
You heard me?
Yeah, what is it called? What's the next definition?
The bill of lading.
So what are we bearing?
The document.
What is the document called
The bill.
of lading?
Hmm.
You see how that's after bear?
Yes. We're bearing the bill. The bill of lading.
And it's
Yeah.
the document that you kept saying.
Right.
But your language, if you take a document to me, that document could be anything, sis. Anything. If you want to make an agreement with me, I'm going to infer it by your language. And if you say document to me, I mean shit, it could mean anything. Or I don't know. What are you talking about? What did
Right.
you bear? What are you bearing? Tell me versus document and leaving it up for me to
Just the lady.
presume. You see?
Yes.
So when we make these agreements, we must be conscious and aware of our language so that the opposing party or the opposite party understand what it is that we want and talking about. Like directly, not indirectly. You saying document to me is an indirect description of what we're talking about.
Right. I just saw something. That is so crazy because the bill of lading is saying that it means that it's the evidence of receipt of goods or ship
Yes.
issued by a person. Wow.
Yes.
Wow. Wow.
Yes.
That's crazy.
Someone who is just the person who engaged in transferring and forwarding those goods. Just evidence. It's
Right.
each and every time gratitude that you receive in that bill, you got a present. For as long as you're in that moment, receive it because it is a good that is issued to you by somebody who is engaged in issuing those goods. You're going to be issued those goods for 72 months.
Right. Wow.
You're going to be bearing it. Everybody is. You, a bank, associations of a bank, all due to an agreement from someone who has the right to pursue a remedy. Take an action.
Hey. So does that mean that you have to specify it as a bill of lading?
If you want to agree on that, if you want the opposing party to agree with you on that, then yeah.
Hmm.
You want them to agree with you that you got documents? Then yes, they will, because you do have a document.
Right.
Do you want to specify what that document is? Could be plenty of things. Certificate of security, negotiable instrument, document of title,
Right.
It could be so many things. And people wonder why they go into the bank and say, well, the bank said they don't take it. Yeah, because what you talking about, you want them to take.
Right.
Because
Wow.
that's how they gonna make an agreement with you based on what you say, not on what they supposed to tell you.
That part.
They gonna deal with you based on exactly what you say.
And that's like, and that's crazy because it reminds me of like you like understanding the value of what you have, but you have to communicate that.
You must first start off by having and find a value in the information and find a value in the terms and the definitions, reading what you see inscribed on a document or right here. You got to start with the information. And so many people want to skip the information because they're so anxious to pay a bill. You are
Right.
never going to learn how to pay it.
Right.
That's the reality. And they knew that. They knew so many people would skip the information. They knew so many people won't read the information. They knew so many people won't connect the dots. They knew it because people can't communicate.
Right.
So they language, it depends on the circumstance.
Yes, it really does.
They knew this, but they ain't hide it. They put it out there, just very in order.
Right.
Because you have law and order. Law is what you create on that principal aspect. When you create the agreement, here's the order.
Right. Right.
So, how you feeling so far?
This is crazy. A lot of wow moments. Like I just can't believe, like you said, the order is here, and I never even seen it for that. Never seen it for that. But now I see the flow.
Good. You're gonna continue to see the flow.
Right. Yep.
You're gonna see, excuse me, you're gonna see the flow with or without. That's the point.
Right.
So I'll go ahead and stop our recording here and stop the broadcast, and we'll pick up our next meeting